Good morning. Tip number 29, Law of Tort. One particular subject, tort as liability between the occupier and visitor. Uh, Most important, day-to-day issues may come, and we are uh, experiencing such a result between occupier and the visitors. So the visitors may be three categories: lawful visitors, trespassers, and children. Premises includes building, car, ship, aeroplane, lift, etc. So wherever this, if you are running a hotel, you are inviting, you are running a shop, selling textiles, and you are inviting, they are not trespassers. Sometimes there is the occupier must have responsibility for the trespassers. Excessive prevention to prevent trespass by live wire electrification or digging and automatic fire guns. These things, so many dangerous method preventing trespassers. That is also not available. Then question of children. Allowing children and to the extent of reaching the premises, just like a terrace. When a child goes to the terrace and fall down, then you are liable. So you must have some common duty care to see that the children are not affected by your premises. Then question arises, what is patent knowledge or latent knowledge about danger? If suppose a fan fell down from without, even though there was periodical inspection, something would have happened by breaking up screws fitted with the fan, and then there will be possibility of in England there is an act, Occupiers Liability Act 1957. Occupiers Liability Act 1957. Another duty was the structures, occupier of structures near highways also have got a lot of responsibility to look about the structures is not disturbing the highways users. This is most important thing. Then the landlord and tenant, even though the building was belonging to landlord, if the landlord failed to reasonably repair or prevent any damage to the building, he is liable for tort as liability. There are multi-number of cases. This is what Cates versus Mongini brothers, wherein the hotelier was held not liable because the screw of the fan fell down. It's a latent knowledge. He was not known about that. Then the cement of the stairs which is fell down or suddenly cracked, then he is liable, because even though concealed danger, it is you have to would have observed earlier about the condition of the stairs cements. That is one case. That is Pearman versus Perpetual Investment Building Society case. Then the case Inrose versus Northern. Two chimney sweepers killed by gas while trying to steal a sweep hole in the chimney of cockfired boiler. Fire was still alight and the occupier was held not liable because they are trespassers. They run a risk. Therefore, then question of highway Kullalal versus Hemachand, AR 1958. There, if he is not maintaining the building properly near highways, he is liable. Then fall of the clock tower, which was situated in the heart of the city. This case was Municipal Corporation Delhi vs. Subhagavanti, AR 1966, SC 1750, strict liability. Then this Noble vs. Harrison, a huge tree which was growing on defendant's land and overhanging the highway. So defendant was not liable because he did not know about that defect in the tree, that is called latent defect. Latent defect means concealed defect. This is what they say. Then against it, towards trespassers, I have already told that trespass by concealed dangers, nature of trap. This is what they say. Cherubin versus State of Bihar, 1964, SC 205. All these things you have to see the judgments to understand the law of tires about occupier of the premises under that caps. British Railway Board was Harrington because the fence which was covering the railway track was in a different condition. Therefore, the Railway Board was held responsible. This is then the question of we should be very careful to see that the children are not sustained any hurt because of the condition of the building. Phillips vs. Rochester Corporation, 1950 plaintiff child page 5 with sister aged 7 to an open space building site different. There the plaintiff fell down. The defendant were held not liable, for there was no reason to suppose the children of tender age will be allowed to wander over the site. But suppose little children are permitted by parents to go unaccompanied in the reasonable belief that they would be safe. That is recognized playground. It's also most important. Defendants were not held liable. Best wishes.